we discuss employee or worker responsibilities as per the ILO and other safety regulations. As per the Article 19 of ILO Convention C155, it is ensuring that all the workers or the employee, they have to cooperate with the employer. It is clearly mentioned in C155 in point A of Article 19 that workers in the course of performing their work cooperate in the fulfillment by their employer of the obligation placed upon him. Like for example, we can see from the live scenario or the practically worker did not cooperate by following the employer instruction and worker started the faulty machine and got accident or injury. So we need to inform to the worker it is their legal obligation to cooperate with the employer for their own safety. As per point B, representative of workers in the undertaking cooperate with the employer in the field of occupational safety and health. For example, a worker did not follow the safety protocol or procedure and used the machine without isolation for the maintenance purpose and become injured. So we can see this example, the worker did not cooperate in terms of occupational safety and health. In the point C, the representatives of worker in an undertaking are given adequate information on measures taken by the employers to secure the occupational safety and health and may consult their representative organizations about such information provided they do not disclose commercial secrets. So from the scenario or from practically we can see the worker was having the opportunity to discuss with the employer or the management, but the worker did not consult with the employer for safety issues and lead to the accident. In point D, worker and their representative in the undertaking are given appropriate training in occupational safety and health. So worker having that chance to get trained, even without training, one worker was trying to rectifying the fault of the machinery and that lead to the injury or accident at the workplace. As per point number E, worker or their representative and as the case may be, their representative organizations in an undertaking or organization in accordance with the national law and practice, they are unable to inquire into and are consulted by the employer on all aspects of OHS associated with their work. For this purpose, technical advisors may, by mutual agreement, be brought in from outside the undertaking. So we can see in particular scenario or practically workers are not taking or not taken any help from the manager or supervisors and did not consult any technical advisors and going to lead to the accident. As per point number F, a worker has to report forthwith to his immediate supervisor any situation which he has reasonable justification to believe presents an imminent and serious danger to his life or health. Until the employer has taken the remedial action, if necessary, employer cannot require workers to return to a work situation where there is continuing imminent and serious danger to life or health. So we can see generally at the workplace, some workers, they are not reporting any unsafe condition to his manager or supervisor, which is going to lead to the major injury or accident at the workplace. We can see the further employee responsibility as per point 16 of recommendation R164 that all the workers need to take reasonable care for their own safety and that of other person who may be affected by their acts or omission at work also need to be ensured that their co-workers should not get affected. All the workers need to comply with instruction given for their own safety and health and those of others and with safety and health procedure. All the workers has to use safety devices and protective equipment correctly and do not render them inoperative. So this is very clear guideline for the workers that they should not make safety devices inoperative or without the technical help they should not modify it. Otherwise it may lead to some serious unsafe condition. As per the point D, all the workers' responsibility to report forthwith to their immediate supervisor any situation which they have reason to believe could present a hazard and which they cannot themselves correct, like any fire occurred or any dangerous chemical spilled on the floor. So report any hazard. If they are did not report any unsafe condition, dangerous situation, unsafe act, then it is going to lead to the further accident or any type of incident at the workplace. In the point E, it is a worker responsibility to report any accident or injury to health which arise in the course of or in connection with work. So they need to report any incident or near miss. They need to report any type of accident which are happening while they are working on the site. So we can summarize the employee or worker responsibility. They need to cooperate with the employer as per convention number C155 article 19. Worker must follow the safety protocol or procedure as per ILO convention C155. Worker need to consult with the employer on safety issues as per ILO C155. All the worker need to take reasonable care for their own safety as per recommendation R164 of ILO. They have to take reasonable care of their others or co-worker safety as per ILO recommendation R164. The other person should not be affected by their acts or omission at work. All the workers need to comply or following with instruction given for their own safety and health as per ILO recommendation R164. All the workers have to use safety devices and protective equipment correctly. They should not render safety equipment or plant inoperative condition and they should not make safety devices inoperative or to modify it. They should report any hazard or any incident or near miss. They should report any injury or accident. They should report any danger or unsafe condition. They should not perform any work without safety. All the worker has to use PPE all the time and all the worker has to follow the site rules. So these are the worker responsibility in summarize. Now we see the contravention point of view where we have to write the negative uh, points where the worker did not follow the safety. So the worker or employee did not cooperate with the employer. This is a contravention. The worker did not cooperate with the employer in terms of health and safety issues or matters. Worker did not follow the safety protocol or procedures. Worker did not consult with the employer for safety issues. The worker has not taken reasonable care for their own safety and health. The worker has not taken reasonable care of their others co-worker safety. Worker has not taken care by the workers that other person should not be affected by their acts or omission at work. Worker not complying or following with instruction given for their own safety and health. Workers did not use the safety devices and protective equipment correctly. Workers rendered safety equipment or plant in inoperative mode, that also become the contravention. Workers make the safety devices inoperative and modified it without the permission of the maintenance authority. The worker did not report any hazard. The worker did not report any accident or incident or near misses. The worker did not report any injury or accident, even then the worker was available, he witnessed, and he is seeing that accident happen or it happened to him itself. The worker did not report any danger or unsafe conditions. Worker did not perform his work with complacency or with safely. Worker did not use PPE all the time, and worker did not follow the site rules. So we can see once we are going to write the answer in the contravention point of view, we have to tell what are the points the worker did not complied or not follow the requirement as per the ILO and other safety regulations. We can see one particular question. The one injured worker and their fellow worker, they have contravened some of their responsibility as per the ILO C155 and associated recommendation R164, occupational safety and health recommendation 1981, number 164, recommendation 16. So we need to comment on the extent to which Article 19 of C155 and recommendation 16 of R164 may have been contravened. Like this question is being asked into the final exam. So like for this question awarded for 10 marks, so then we can take the help of the scenario or whatever the question paper allocated to us. So we need to mention the breach or not fulfilling guideline by injured worker and their fellow workers and comment on the contravention only. And here we should not directly copy paste from the convention C155 and R164 from the ILO. And while you are preparing your answer, use the 330 words and 10 points minimum. After searching from the ILO, write all the contravention which are available in the your given scenario. So like this way, we can have one question based on the scenario. Now further we see some common questions. Explain the main health and safety responsibility workers or workers as per ILO convention C155. Another type of question being asked, what are the legal responsibility and right of the employee? Based on the scenario, we can write the answer. Another question is being asked, comment on the worker's responsibility. Question number 4, comment on the worker's responsibility which have been contravention or contravened. Question number 5, comment on the worker responsibility which have been fulfilled or complied. Like this question is being asked into this particular syllabus during the exam. So we can, by reading this particular topic, we can get the complete idea.